Hi, this is Dan Smith of DPS Legal Counsel, and welcome to today's video and podcast episode of Business is More Exciting Than Any Game. Today I want to talk about a recent case from the Supreme Court of Alabama. It just was released as a published opinion on April the 23rd of 2021, and the name of the case is Boyd versus Mills. The reason this case is interesting and why it's helpful for business owners to know about is that it addressed a very interesting but novel question of law involving non-competes. And for businesses, having a non-compete or selling a business and trying to enforce a non-compete against a selling party is of particular importance to businesses. And so what this case involved was a sale of a business, and pursuant to the sale, the parties entered into a separate contract for a covenant not to compete with the selling owner of the business. Essentially, the selling owner was going to be paid over $2 million over the course of about 10 years, 120 months, paid monthly, an amount which in total would be about $2 million, more than that, but around $2 million. And so the selling owner was getting $17,000 or thereabouts per month over the course of this 10-year period. But what happened was that before this full 10-year period ran, the selling owner of the business died. And so the purchasing the buyer of the business continued making payments on the covenant not to compete for some period of time, but at some point stopped making them and said essentially that because the selling owner had died, the covenant not to compete had ended, had terminated, and so there was no reason to continue paying for that covenant not to compete. The estate of the selling owner sued, and that's what this case was about. When you get down to it, what's the key point is what type of contract is a covenant not to compete? Is it a contract that survives death, or is it a personal services contract that's personal to the selling party, like in this case, the selling owner, that it's personal to him, and typically personal services contracts terminate upon a person's death. They do not survive the person's death. So the question was, is this covenant not to compete a personal services contract that ended when the selling owner died, or is it something else? Court looked at cases from other jurisdictions, including Ohio and I believe Florida, and came to the conclusion that because this covenant not to compete was separate from the sales contract for the business and did not include affirmative obligations on the part of the selling owner, only negative covenants, in other words, will not compete, will not encourage or solicit customers from that business, will not solicit or encourage people to leave the employment of that business. All negative covenants, not any affirmative covenant, that this was not a personal services contract, and so it did survive the death of the selling stockholder, and so the covenant not to compete remained enforceable and had to be paid up even after the selling owner's death. Now, the court did point out a case in which there were some affirmative covenants in another case, another state, involved in a covenant not to compete, such as being available to answer questions or respond to questions about the business from the purchasing company. And in that case, because there were affirmative covenants, it was treated as a personal services contract, and upon the death of the selling owner, the covenant not to compete was deemed to not survive, and so payments could cease on that covenant not to compete. Now, I haven't done a full search, but I haven't found a case in Tennessee exactly on point. So this is important. This is an important case for people to know about, even in Tennessee. As I said, this was a case of first impression for the Supreme Court of Alabama. It just came out a little over a week ago. I would say takeaways or lessons from this case, there are a few. One would be, if you're involved in a transaction in which there's going to be a covenant not to compete, and payments are going to be made over a period of time on that covenant not to compete, like for example in this case, paid over a 10-year period on a monthly basis, you want to make very, very clear in the contract that the obligation of the buyer to continue payments on that covenant not to compete will survive the death of the selling owner. You might also want to include in the contract language that this is not a personal services contract, and also be careful not to include provisions in there that would be affirmative covenants on the part of the selling owner. If you want to have affirmative covenants, you probably should put them in a separate agreement apart from the covenant not to compete. Finally, you probably would also want to include a typical standard inurement clause, which basically would say that upon the death of a party, that the benefits and burdens of obligations of the contract inure to the heirs and successors of the parties. If you do those things and make abundantly clear that payments are to be continued even after the death of the selling owner, you should be in good shape. But this case just highlights how important it is to be clear in your contracts, and particularly if you have a payment obligation that extends over a period of time, make it very clear that the death of one of the parties does not terminate the obligation to continue to make that payment. Now again, that case is from the Supreme Court of Alabama, Boyd versus Mills. Take a look at it. It could be of interest to you and your business. Thanks. We'll see you next time on Business is More Exciting Than Any Game.